Alright, Subpart B, Enforcement 19201. Purpose of the scope of the Subpart to describe the enforcement authority of the sections of the exercise of the associated minute with the chief of the maintainment of the pipeline safety compliant with the Title 49 U.S. Standard Code 6101 and 10 sequence to 33 U.S. Standard Code 1321J, any of the regulation order issued thereon or thereof prescribed and perceived of the governing of the exercise of the authority of the imposition of the sanctions. A person who is subject to the action pursuant with the subpart may be represented with the legal counsel at all stages of the proceeding. 190 203 Inspection Investigation Officers employs agents authorized by the Associated Administrative Pipeline Safety of the PHMSA upon the request presenting appropriate credentials authorized to enter upon the inspection, examine in responsible times and responsible manner the records and property to a person extent with the records of the property that are relevant to determine the compliance of such a person the requirement of the Title 49 Standard Code 6101 or regulations of the ordered issue there under inspections ordinarily conducted pursuant to one of the following routine scheduling with the regional director of the region over which the facility is located compliant, received from the member of the public information obtained from the previous inspection report of the state agency participating federal program under Title 49 U.S. Standard Code 6105, pipeline accident or incident, whenever deemed appropriate with the associated administrator. If the Associated Administrator Regional Director believes that further information is needed to determine the appropriate action, the Associated Administrator Regional Director may notify the pipeline operator with the written with the operator required to provide the specific information within 30 days from the time of the notification received by the operator, and if otherwise specified by the notification must be provided with a reasonable description of the specific information required, and operator may request extension time to respond with providing written justification as to why with such extension is necessary to propose alternative submission date. The request for the extension may ask for the deadline to be stayed. While extension is considered a general statement that the hardships are not acceptable, they cover the requesting of the extension. The extent of the necessary to carry out with the responsibility under Title 49 U.S. Standard Code 6101, the extent sequence of the administrator of the associated administrator may require the testing portion of the pipeline facility that have been involved with or affected by the accident. However, before the exercise of the authority of the administrator of the associated administrator shall make every effort to negotiate mutually accept the plan within the owner of the facility and where the appropriate of the National Transportation Safety Board for the performing testing. If the responsibility of the U.S. Department of Transportation inspector for the investigation accident for the incident involved in the pipeline facility, the operator must make available the representation of all the records in form of the purchase into the event of any way, including the integrity management plan for the test result. The operator must provide all reasonable assistance in the investigation. Any person who is object to the inspection investigation taking actions where known that presumably should have been known to prevent, hinder, and impede the investigation without good cause will be subject to the administrative civil penalty under the subpart. The operational pipeline safety determines if the information obtained from an inspection or from other appropriate sources warnings. Further, the operational pipeline safety may initiate one or more enforcement proceedings described in this subpart. 190-205 warnings. You determine the probable violation. Title 40 U.S. 49 U.S. Standard Code 6101, 10 sequence 33 U.S. Standard Code 30. Title 33 U.S. Standard Code 1321. Any regulation or other orders issued under the Associated Administrative Regular Regional Director may issue the written or warning notifying the operator of the probable violation, inviting the operator to correctly to be subject to the potential enforcement action of the future of in the future. The operator may submit the response with the warning, but not required to an injunction under the subpart of the determine whether the violation occurred if it is not conducted for warnings. 192-106 Amendment of the Plans and Procedure Regional Director being with the proceeding to determine whether the operation plan with the procedure required in parts 192, 193, 195, 199 with the subject inadequate to assure safety operation pipeline facility. Issuing notice of amendment. The notice will specify the alleged inadequacies and the proposed revision of the plans and procedure provided by the opportunity to respond. The notice will allow the operator 30 days from the following receipt of the notice for the subwritten comment of the revised procedure and request of the hearing under 192-11. After consideration, all material properly presented with writing and of the hearing, if applicable, the Associated Administrator determines whether the plan proceeds with the inadequate with the alleged Associated Administrator issue their other directing amendment over the plan's procedure if they are inadequate without withdrawal of the notice if they are not. If determine the adequacy of the operation plan with the procedure, Associated Administrator may consider relevant pipeline safety data where their plans are perceived appropriate with a particular type of the pipeline transportation facility, the location facility, and the responsibility of the plans and perceived the extent with which the plans and procedures contribute to the public safety in order directing an amendment of the operating plan of the procedure prescribed in this section made additional to the conjunction with or appropriate enforcement actions prescribed in this subpart. 192-107 notice of the probable violation, except for the otherwise prescribed in the subpart of the regional director, given begins with the enforcement proceeding with the serving the notice of the probable violation on a person charging the person with the probable violation. Title 49 U.S. Standard Code 6101. Title 33 U.S. Standard Code 1321, or any regulation order issued thereunder. A notice of the probable violation issued with this section include the same provision of the law, regulation, order which respondent alleged to have violated with the statement of the evidence upon the allegations are based. Note that the response option available to the respondent 19208. If the civil penalty is proposed in 19221, the amount of the proposed civil penalty and the maximum civil penalty for which the respondent is liable under law. If the compliance order is proposed under Title 19217, the statement of the remedial action being sought in the form of the proposed compliance order, the regional director may amend the notice of the probable violation any of the time order issued with the final order of the 19213 if the amendment include any new material allegation of fact for the fact proposed the increased civil penalty amount, then propose a new additional remedial action on 19217, and then the respondent will have the opportunity to respond in 19208. 19208 responsive option. When the 30 days receive the notice of the probable violation, respondent must say to the regional director who is issuing the notice of the following: when the notice contains the proposed civil penalty, if the respondent is not contesting the allegation of probable violation, may propose civil penalty provided in Statute 19227 and by the regional director for the payment that authorizes the associated administrator to make the finding violation and issue the final order 19213. If the respondent is not contesting the allegation probable violation, wishes to submit the written explanation, information, or other material the respondent believes that may warrant the mitigation elimination of the proposed civil penalty, the respondent may submit such material that authorizes the associated administrator make the finding of the violation to issue the final order 19213. If the respondent is contesting one or more allegation probable violation but is not requesting hearing under 19211, the respondent may submit written response in the answer to the allegation. The respondent may request the hearing in 19211 with a notice of containing the proposed compliance order with the respondent no contesting allegation proposed violation agree the proposed compliance order the authorized associated administrator to make the finding of the violation and to issue a final order in 19213. The execution of the consent order 19219. The respondent is consisting one of the more allegation probable with the violation compliance terms, but is not requesting a hearing of the 19211. The respondent may object with the proposed compliance order, submit the written explanation, information, or other materials in answer for the allegation in the notice of the probable violation. The respondent may request a hearing in 19211. Before or after the responding in accordance with the paragraph A of the section or with the applicable paragraph B, the section respondent may request a copy of the violation report with the regional director set forth in 19209. Regional director will provide the violation report with the respondent with 5 business days and of receiving the request. The respondent in accordance with paragraph A of the section will applicable to paragraph B of the section constitute the waiver of the right to concept of the allegation of the noticeable probable violation authorized by the associated administrator without further notice as a respondent to find with the facts as the alleged and noticeable probable violation issue of the final order 19213. All material submitted to the operation respond with the enforcement action may be displayed with the publicly accessible to the website. Respondents seek the confidential treatment of the under Title 5 U.S. Standard Code 552B by any portion of the responsive material must provide a copy of the such material along with a complete original document. The respondent may redact the portion of the qualified with conventional treatments, and the second copy but must be provided with a written explanation each redaction. 19209 case file. The case file is defined in the section available to respond with all the enforcement proceedings that conducted within the subpart of the case file with the enforcement proceedings consists of the following in the case of the under the 19206 with the notice for the amendment of the relevant procedure to the case the commenced under 19207 with a noticeable probable violation in the violation report. In this case, committed order with a 99213 of the corrective action or notice of the proposed corrective action or data report of the one prepared. And 4, in case the commenced order 19239 with the notice of the proposed safety order. Any documents other than material submitted with the respondent with enforcement action casing involved in the hearing, any submitted material submitted during and after hearing set forth in 19211, and the regional director's written evaluation response submit material submitted with the respondent and recommendation of the final action is one prepared. 19210 separation of functions. Generally, an employment through is an agency employee who, with a specific investigation, prosecute for the enforcement may call but not participate with the discussion of the case of the factual related one, but may participate with witness and counsel at the hearing as set forth by the Subpart. Likewise, the agency employee who will prepare for the decision in the emergency enforcement case may not serve the investigation of the prosecutorial capacity in the case of the faculty related one. Alright, prohibition ex parte communications. A part of the enforcement of the proceeding involved with the respondent with its representative of the agency and the employee have served the investigative, the prosecutorial capacity in the proceeding, but may communicate with privately with the associated administrative presiding official with the attorney drafting recommended decision conforming concerning the information that is relevant to the question and to be decided by the proceeding, as part may communicate with the presiding official regarding administrative procedural issues such as scheduling a hearing. Or 192.11, the hearing. The general this section applied with the hearing is conducted with the part relating to the civil penalties assessment compliance order directing amendment safety over the correction action orders for the presiding official that will convey with the hearings conducted under the section hearing and request the statement of the issue of the request for the hearing must be accompanied by the statement issued of the respondents intend to raise the hearing of the issue may relate with the allegation of the note of the proposed corrective action with the proposed civil penalty action with the respondent failed with safety specify the issue may result with the waiver of the responding right to raise the issue with the hearing. The respondent request must be also indicate whether or not the respondent will be presented with the counsel at the hearing. The respondent may withdraw with the request for a hearing and the written provide with a written response. Telephonic and in-person hearing. Telephonic hearings will be held with the amount of the proposed civil penalty of the cost of the proposed corrective action left within $25,000 and left the respondent with the operational pipeline safety to submit the written request for an in-person hearing. In the person hearing will normally be held at the office appropriate with the operational pipeline safety region. The hearings may be held with a video with teleconference and necessary for the equipment is available to all parties. Pre-hearing submission, operational pipeline safety with the respondent attempted to introduce the material including the records, documents, and other exhibits with not already in the case of the file. Material must be submitted to the presiding official with the other party at least 10 days prior to the day of the hearing. Left the presiding official set a different deadline and waive the deadline for good cause. Conducting the hearing is conducted formally without the strict adherence of the rules of evidence. The presiding official will regulate the course of the hearing, gives to each of the party the opportunity to offer facts, statements, explanations, documentations, testimony, and the other evidence relevant to the material of the issue under the consideration. The parties may call the witness on their behalf, examine the evidence witness presented over by the other party after the evidence of the case has been presented with the presiding official will permit the responsible discussion of the issues under consideration. Written transcript or response with the elected to transcribe the hearing. The respondent may must take the arrangements of the court report as the cost of the respondent, submit the complete copy of the transcript for the case file. The respondent must notify the presiding official in advance the intends the transcript of the hearing. The post-hearing submission of the respondent with the operational pipeline safety may request the opportunity to submit further written material of the hearing with the inclusion in the record. The presiding official will allow reasonable times for the submission of the material. Will specify the submission date, but then the material does not submit with the time prescribed in the case to proceed to final action without the material. Preparation of the decision after consideration of the case file. Presiding official may recommend the decision in the case forward with the associated administration final order. 192.12. The presiding official power of the duty of the presiding official for the hearing conducted with 192.11. The attorney of the staff of the deputy the chief of counsel not engage in such any of the investigation prosecutorial function, such as issuing the under the subpart is designated the presiding official unavailable to the deputy chief of the counsel may delegate the power to do to specify with the section any attorney, another attorney of the office of the chief of the counsel who is not engaged in any of the investigation prosecutorial functions under this subpart. Time and place for the hearing. The presiding official will set the date and the time and the location for the hearing. Instead of the practical with the presiding official will accompany with the part of the schedule for the setting of the hearing. Reasonable note for the hearing will provide all the parties powers and duty of the presiding official. The presiding official will conduct the fair, impartial hearing, take all the action necessary to avoid delay. The decision proceed with the main order. Maintain order. The presiding official will also power necessary to achieve those and with limited power to regulate the course of the hearing and conduct the parties and their counsel. Receive the evidence, inquire into the relevant material facts, require the submission of the documents and other information direct with the documents of the brief relate the issue raised during the course of the hearing, set the date of the following documents, brief and the other items, prepare recommendation decision, exercise the authority necessary to carry out the responsibility of the presiding official under this part. 192.13, final order. Enforcement proceeding with the comments for the 192.07, the attorney of the official chief counsel to prepare for the recommended decision after the expiration of the 30-day response period for the prescribed 192.08. If the hearing is held, the presiding official prepare for the recommended decision as set forth in 192.11. The recommended decision forward with the associated administrator who consider the case of the file issue the final order. The final orders include the statement of the finding with the determination with all the material issues, including determination whether to such alleged violation has proved the civil penalties, the seventh amount of the penalty, procedures and payment penalty and payment of the penalty prescribed with the assessment of civil fee. Civil penalties may not exceed the penalty proposed in the notice of probable violation. If the compliance order is issued, the statement of the action required by the taken by the respondent within the time by which such actions must be accomplished. In the case where the substantial delay expected with the issuance of the final order of the fact of the date with which expected the action will take is provided with the respondent upon request whenever practicable. Alright, 192.15, compliance orders. 192.17, compliance orders generally. Regional Regional director has reason to believe that the person engaging in the conduct of Title 49 U.S. Code 6101. Alright, U.S. Title 49 U.S. Code 60101. Title 33 U.S. Code 1321J, any regulation order issued thereunder. If the nature of the violation public interest was warranted, regional director may initiate proceedings under 192.07 through 192.13 to determine the nature of the extent of the violation, aim for inference, issuance order, directing compliance, consent order, and at any time prior to the issuance of the compliance order, or 192.17 of the corrective action of the 192.33. Safety order 192.39 of the regional director of the respondent may agree with the result of the case for the execution of the consent with agreement and order which may be jointly executed with the party of the issue with the associated administrator upon the quick assumption execution of the consent order conserved with the final order under the 192.13 consent order executed under the paragraph 8 of this section shall include an admission by the respondent with all jurisdictional function, facts, plus waiver for the procedural steps, and all right to seek the judicial review otherwise shall the content of the validity of the order, and ultimately the notice of the probable violation may be even construed the terms of the consent order, statement of the action required by the respondent at the time by which such action will accomplish prior to the execution of the consent agreement order rising out of the corrective action order under the 192.13 the associated administrator notify the appropriate state official. And in accordance with the Title 49 U.S. Code 6112 C. Alright, civil penalties 192.21. Civil penalties general. The regional director have the reason to believe the person committed any act of violating the Title 49 U.S. Code 6101 attends sequence Title 33 U.S. Code 1321J and a regulation order issued there under regional director may initiate proceedings under 192.07 through 192.13 to determine the nature of the extent of the violation appropriate as civil penalty. 192.23 maximum penalties. Any person having violated provision 1 for Title 49 U.S. Code 6101 attends sequence any regulation order issued there under is subject to the administrative civil penalty not exceeding statute 209 not exceeding $209,000 and $2 for each violation. For each day of the violation, continue with the maximum administrative civil penalty not exceeding $2,090,022 for a related series of a violation. Any person found to violate the provision in Title 33 U.S. Code 1321, any regulation order issued thereunder from the subject of the administrative civil penalty of Title 33 U.S. Standard Code 1321 B 6 as adjusted in Title 40 CFR 119.4. Alright, any person found to have violated any standard under the Title 49 U.S. Code 6103, the subject of the administrative of the civil penalty exceeding $76,352, which made additional to the other sub-penalties to such person may be subject to the paragraph 8 of the section. Any person determined to violate with the standard of the order of the Title 49 U.S. Code 6129 is subject to the administrative civil penalty exceeding $2,214, which may be in addition to other penalties which such person may be subject to them. Paragraph 8 of the section. Alright, separate penalties violating regulation prescribed the subchapter violating order issued in 192.01. Sorry, I got a cold. 192.06, 192.13, 192.33, 192.39 may not be imposed under this section. Both violations are based on the same act. 192.25 assessment consideration. Determine the amount of civil penalty under this part. The associated administrator will consider the nature of circumstance with the gravity of the violation, including the adverse impact of the environment, the degree of the respondent, the culpability, the respondent history of the prior offense, any good of the faith of the respondent attempting to achieve the compliance, the effect of the respondent, ability to continue the business, the associated administrator will consider the economic benefit gained of the violation readily ascertainable with any other reduction because of the subsequent chain damages. Such other matters of justice may require. Alright, 192.27 payment of penalty. The except for the payments exceeding the $10,000 payment of the civil penalty proposed with the assessed owner with the subpart may be certified check in the money or the contained with the CPFR number for the case of payable to the U.S. Department of Transportation to the Federal Aviation Administration, Mike Maroney, Aeronautical Center, Financial Operation Division, AMZ 341, PO Box 25770, Oklahoma City, or 73125, or rate transfer through the Federal Reserve Communications System, FedWire, the account of the U.S. Treasury via pay.gov payments and conceive $10 million may be made to the wire transfer. The payment of the civil penalty is assessed when the final order issued within 192.13. The firm of the decision on petition reconsideration must be made within 2 to 20 days after the receipt of the final order decision. Final to do so with the failure to do so result in the initiation collection action, including the accrual and interest and penalties in accordance. 192.29 through 231 reserved. Specific relief. 192.33 corrective actions. Generally accepted to provide with the paragraph B of this section is associated administrative fine with a reasonable notice of the opportunity for the hearing the record hearing according to the paragraph C of this section. Particular pipeline facilities is used as it would be hazardous to life, property, and environmental. The associated administrative issue of the order pursuant to the section requirement of the opportunity of the operator of the facility to take the corrective action. Corrective action may include suspend and restrict the use of the facility, physical inspection, testing, repair, replacement, and other appropriate action. Waiver and notice of the expected of the review of the associated administrative waive the requirement to know for the opportunity of the hearing under the paragraph A of the section before issuing an order whenever the associated administrative determines the failure to do so would result in the likelihood of serious harm to the life, property, or the environment. When an order is issued under the paragraph that respondent of the contest, the order may make the respondent that contest the order may expedite the review of the order either by answering the writing and the other within 90 days of the 10 days of the receipt, requesting a hearing in 192.11 to be held with such practical according to the paragraph C2 of the section. For purpose of the section of the expedited review that define with the proposed making prominent determination whether the order shall remain in effect with the amendment determined with the expected expedited review of the order issued under the paragraph will be complete with upon issuance of such determination. Notice and hearings written note that the operational pipeline safety intends the issue of the owner of the section will be served upon the owner and the operator of the alleged hazardous facility in accordance with the 195 with the note of the alleged existence of the hazardous facility, save the fact that the circumstances supporting the issue of the corrective action order, know there must be an owner of the provided the owner and operator with the opportunity to respond with a 10-day receipt. All right, an owner of the operator with the elect the exercise of the opportunity of the hearing and associate section will notify the associate administrator of the election with the writing within 10 days of the receipt of the notice to provide the paragraph C1 of the section order with the paragraph B of this section within when application for the absence of the written notification when waive the owner of the opportunity of the hearing. 3. Anytime of the issuance of the notice of order under the section, respondent may request for the copy of the case filed and set forth in 192.09. A hearing under the section conducted the pursuant of 192.11. The hearing should be held the 15th day after the receipt. Respondent requested the hearing after conclusion of the hearing under the section of the presiding official submit the recommended decision associated administrator as to whether or not the facility would have the hazard to life of the property or the environment if necessary or expeditious corrective action. The notice of order is consent with the writing of without hearing. An attorney office chief of the council prepare with the recommended decision. Recommended decision should be submitted by the associate administrator 5 business days after the conclusion of the hearing. After the receipt, writing objection to the hearing that is held upon receipt of the recommendation, the associate administrator will proceed in accordance with paragraph D through H of this section. An associate administrator of the facility would be hazardous to the life of the property environment if the associated administrator of the corrective action order with accordance with the section forms the amendment of the corrective action order issued on paragraph B of the section. If the associated administrator does not find faculty find the facility or does not find the facility is or would be hazardous to life, property, environment, the associate administrator withdrawal of the notice to determine the order to issue in paragraph B of this section promptly notified the operator with the writing and service of the prescribed 195. The associate administrator may have the pipeline facility as if the paragraph A of the section, if under the fact of the circumstance of the associate administrator determine the particular facilities hazardous to life and the property of the environment, the pipeline facility that come over there would be constructed the operator with the equipment, material, with the technique of the associated administrator to determine the hazard for the life of the property of the environment, unless the operator involved with the demonstrate with the certification of the associated administrator acts. The associated administrator of the under the particular fact of the circumstance involved with the equipment and material, the technique of the not hazard. Make a determination on paragraph D of the section. The associated administrator shall consider the relevant the characteristics of the pipe and the other equipment of the pipeline facility involved with including its age, manufacturing, physical property, including resistance to the corrosion, deterioration, method of the manufacturing, construction, assembly of the nature of the material transported to such facility, including their corrosive, deteriorative qualities, sequence in which some of the such material and transported with the required and such character or transportation character of the geographical area of the pipeline facility located with particular with climatic, the geological conditions, including soil characteristics associated with such area with the population density, population growth, and patterns in such areas. Any recommendation National Transportation Safety Board in connection with any of the investigation conducted by the board and such other factors associated with the administrator may consider it appropriate corrective action in order to contain the following information: finding the pipeline facility would it be hazard to life, the property, of the environment, the relative of the fact, for the form of the basis, for the finding legal basis, for the order, the nature of the description, any of the particular corrective action required of the respondent, the date of which required the corrective action must be taken with the believable where appropriate the direct duration of the order. If the opportunity of the hearing was waived for pursuant to the paragraph of the section statement, if the opportunity of the hearing will be available at a particular time and location after the issuance of the order, associated administrator will terminate the corrective action whatever the associated administrator determines the facility longer has with the life, the property, with the environment. If the appropriate, however, with notice of the probable violation may be issued in 19207 at any time the corrective action is issued, the section has become effective. The associated administrator request the Attorney General to bring in accordance and bring in an action appropriate with the relief in accordance with 19235. Upon petition of the Attorney General, District Court of the United States shall have the jurisdiction and enforce the orders issued within the section appropriate means. 19235 Civil action generally. Whenever the pairs of the associated administrator person is engaged and about to engage in any act is constituting a violation provision Title 49 U.S. Standard Code 6101 and Tennessee with any regulation issued there under the authorities, there under the administrator and the person with the authority have the delegated may request the Attorney General to bring into action the appropriate U.S. District Courts of such relief if necessary appropriate, including the mandatory prohibitive injunction, relief of the intermittent equitable relief of the civil penalties punitive damages provided in Title 49 U.S. Standard Code 6120 and Title 49 U.S. Standard Code 5123. 19236 the emergency order. Determination amendment have the administrator determine the violation provision of the federal pipeline safety regulation order prescribed under those laws the unsafe condition of the practice of the combination of unsafe condition that practice of the constitution such causing imminent hazard defined in 193 with the administrator may issue the imposing emergency order without advance notice of the opportunity for the hearing. The basis of any of the action taken under the section will be set forth in writing of the described violation condition of the practice of the constitution the causing the imminent hazard of the subject of those subjects the order, the restriction, prohibition, safety measures imposed, stand for the procedure of obtaining the relief of the order, however the order tailored due to the debate with the imminent have the and recent with the authority under Title 49 U.S. Code 6112, 6117 and 1, and in addition to do so, however, the consider the list of the paragraph C of the section we're taking into account consultation requirement evaluating the consideration of paragraph C of the administrator shall consult the administrator to determine the appropriate with the appropriate federal agency, state agency, other entities knowledgeable in pipeline safety operation. Consideration prior to issuing the emergency order, the administrator must consider the following: the impact of the emergency order of the public health safety, the impact of the, if any, of the emergency order of the national, regional economy, the national security, impact of the emergency order of applicability owners and pipeline safety to maintain the reliability continuity of service of the customers, and the result of the consultation with the appropriate federal agency, state agency, the other entities knowledge of the pipeline safety operations. Services administrated with the published emergency order of the Federal Register as soon as practically upon issue in addition of the operational pipeline safety will boast the emergency order of the website of the emergency order will contain the following service documents including the address of the Department of Transportation docket operations, all persons to be served with the petitions of review. 19237 the petition of the further review, the requirements and either of the subjects agree with the emergency order of the petition of the administrator of the review to determine whether the order remain in play with the modified determinate of the petition. Review must be in writing, save with particular each of the part of the emergency order result of the demand with the resign and include the information evidence with the augments and support thereof. The state whether the formal hearing in accordance with Title 5 U.S. Code 554 to request that the sum of the material facts over the dispute that are given the reason around the request for the hearing be filed with the service in accordance with the paragraph F of the section. Respond to the petition of the review internal to designate of the office of chief of the council may file the service in accordance with the paragraph F of the section. Response including the appropriate pleadings 5 days of the receipt of the petition. The chief of the council, associated administrator of the pipeline safety responsible hearing requested upon receipt of the petition, review the emergency order that included the formal hearing request and states material facts in the dispute with the associated administrator of the pipeline safety immediate assigning the petition with the office of the hearing the Department of Transportation unless the associated administrator of the pipeline safety issued an order stating the petition fails to set forth the material facts in dispute will be decided with under paragraph C2 of the section. Petition for review, including with the formal hearing request, will be deemed the sign of the official hearing 3 days after the associated administrator of pipeline safety receives it. No hearing request for petition for the review of the emergency order that does not include with the formal hearing the request fails to state with the material fact of the dispute. The associated administrator of pipeline safety may issue the administrative decision on the merits of within 30 days of the receipt of the petition. Associated administrator for the pipeline safety decision constitutes the administrator agency final decision. Consolidation. A. Associated Administrator of the Pipeline Safety received more than one petition for the review of the emergency order. Those petitions share the common issues of the law. In fact, the Associated Administrator of Pipeline Safety may consolidate these petitions in purpose of complying with this section. Agency authority to request formal hearing. In the event that the petitioner does not require the request of formal hearing, the Associated Administrator of the Pipeline Safety will still reassign the petition of the Office of the Hearing the Department of Transportation when reasonable basis exists for the reassignment. Formal hearings can be conducted with the administrative law judge assigned with the chief of the administrative law judge, the Office of the Hearing, the administrative law judge, administrative oath and affirmations issued without subpoenas that provide by the appropriate agency regulations, Title 49 CFR 197, Title 49 U.S. Standard Code 6117. They have the relevant federal rules, civil procedure, the United States District Court with the proceeding governing with the hearing with appropriate, adopt the federal relevant federal rules, evidence for the United States Court, magistrate for the submission of the evidence appropriate, taken and cover the depositions to be taken and examine the witnesses at the hearing, rule on offers of the proof of the received relevant evidence. Conveying, recess, adjourning, and other wise regulated with the court for the hearing, hold of the conference settlement with the simplification issue for the other proper purpose to take any of their action authorized to consent with the provision of this part permitted with the law, but may expedite the hearing aid with the disposition of the issue raised. Parties of the petitioner may apply. The petitioner may appear with the position of the authorizing representative of the PHMSA will be represented by an attorney designated with the office. Chief of the council, final service, each of the position, pleading of the motion with the notice of the order without the documentation submitted with the connection of the order issued on the subpart must be filed with the commercial delivered and submitted electronically with the U.S. Department of Transportation docket operation M30 West ground floor of room W12 140 1200 New Jersey Avenue Southeast Washington DC 20590. All documents filed with the publishing document management of the regulations.gov. The emergency order was stated the above filing requirements for the address of the Department of Transportation operation. So each of the documents is according to the paragraph F1 of this section and concurrently serves with the following person: Associated Administrator of the Pipelines, Safety, Operational Pipeline Safety, Hazard Material Safety Administration, U.S. Department of Transportation, 1200 New Jersey Avenue Southeast, East Building, Washington, D.C. 20590. Chief Counsel of the Pipeline, PA2 Pipeline Hazard Material Safety Administration, U.S. Department of Transportation, 1200 New Jersey Avenue Southeast, East Building, Washington, D.C. 20590. Fast Mile, 202-366-7041. Petition reviewing the request for the formal hearing, Chief of the Administrative Law Judge of the U.S. Department of Transportation, Office for the Hearing, N20, room each, 12320, 1200 New Jersey Avenue, Southeast Washington, D.C. 20590, fast mile 202-366-7536. Service must be made personal with the commercial delivery service by the external electronic means with intent if in consent with the written party to be served, except if the otherwise provided with the hearing emergency order must otherwise be relevant. The certificate requirements lift the person be served with the up to date with the necessary certificate of the certificate each for the order plate. Hearing motion of the notice of the other document must be accompanied by the certificate. The certificate specifying the manner in which for the date of which for the certificate is made applicable. Certificate upon the person duly authorized representative, the agent of the certificate, the organization president with the constituted the certificate upon the request, service upon the person. Report of the recommendation of the administrative law judge of the must issue the report of the recommendation of the code of the record. The report of the recommendation must contain the finding of the fact of the conclusion of the law, the grounding of the decision made for the material issue of the fact of the law of the representatives of the record be served on the party of the proceeding be issued with no later than 25 days after the receipt of the petition from the Associated Administrative Pipeline Safety petition of reconsideration party, but they agree with the administrative of the law judge of the report. The recommendation may file with the petition reconsideration Associated Administrative Pipeline Safety within 1 day of the service of the report. Recommendation of the opposing party may fail with a response with the petition with the reconsideration within 1 day of the service of the petition of reconsideration. Associated Administrator of the Pipeline Safety must issue the final agency decision in 3 days after the final pleading outline with the paragraph H1 of the section no later than 30 days after the receipt of the original petition for the review. The Associated Administrator of the Pipeline Safety decision merits of petition reconsideration constitute the agency final decision. Our judicial review after issuing the final agency pursuant to the paragraph C2 and the H3 or H3 of this section, issuance of the written determination administrative of the pursuant to the paragraph J of this section. A person subject to the agreed to any emergency order issued under the section 192.30 should give the main with the judicial review order appropriate the district court United States filing an action from the seeking of the judicial review that does not state the modified force of the effect of the agency final decision on paragraph C2 and the H3 of this section. Written determination on the paragraph J of this section left the state modified administrator. Expiration order. The expiration of the order. Associated Administrator of the Pipeline Safety Administrative Law Judge, where the appropriate time to dispose of the petition for the review of the 30 days of the receipt of the emergency order will see what is expected unless the administrator issue the emergency order determines in writing the imminent have the providing with the base for the emergency order and continues to exhibit the time and computing in any of the period of the time prescribed in the part of the order with the issue of the administrative law judge of the day of the filing with the petition with the review any other act with the default with the wish for the design period of the term time begin with the room that will not include the last day the period that can be so computed with including the left of the Saturday and Sunday federal holidays, in which the event period runs until the end of the no next day, which is not one of the affirmation days. 19239 safety orders. When may PHMSA issue a safety order? The Associate Administrator found that after the notice opportunity of the hearing under paragraph B of this section, particular pipeline facilities and condition of the conditions of those pipeline integrity risk of the public safety property of the environment, the Associate Administrator may issue other requiring operator of the facility to take the necessary for the corrective action. Such action may include physical inspection with the testing of the repair of the other appropriate action remedy with the identified risk condition. How is an operative notified of the proposed issuance of the safety order and what are the responsive options? One, note for the proposed safety orders. And the PHMSA will serve with the written note of the proposed safety order with 195 of the operative pipeline facility. The notice will allege the existence of the condition of the proposed that pose the pipeline integrity risk of the public safety of the property of the environment. See the facts and circumstances support issuing the safety order for the specified pipeline for the proportion of the there is no specify the proposed testing and evaluation integrity with the assessment. Other actions taken by the operator may propose that take the operator submit the work plan and schedule the draft conditions, identify the notice. Notice will also provide the operator with a response option, including the procedure of requesting informal consultation and hearing the operator with the receipt of the notice will have 30 days to respond to PHMSA official who has issued the notice. Informal consolation. Upon the timely request of the operator, the PHMSA will provide the opportunity informal consultation concerning the proposed safety order. The subsequent informal consolations shall commence for the 30 days provided the PHMSA may extend the time of the request. The otherwise could call the informal consultation provided the opportunity the respondent to explain the circumstances associated with the risk conditions, identify with the notice where appropriate the presence of the proposal of corrective action without prejudice to the operational position. Subsequent hearing with the respondent with the regional with the director of the agree with 30 days with the information consultation of the plan with the operative of the director of each for the risk consolidation the answer for the written consent agreement. The associate administrator may, if the consent order incorporating with the term of the agreement, if the consent of the agreement is reached, no further hearing will be provided in the matter. Any pending hearing request will consider the withdrawal and the consent of the agreement is not reached within 30 days of the informal consolation or informal consolation is not requested. Associated Administrator may receive the paragraphs B3 through H of this section. PHMS subsequently determines the operator has failed to comply with the terms and consent of the PHMS may obtain the administrative judicial remedies available to Title 49 U.S. Standard Code 6101 and in sequence of heart with the consent of the agreement does not reach for the administrator may be the operator during the informal consolation should be excluded from the record and subsequently here with nothing in the paragraph B with the precludes the PHMSA has from terminating the informal consolation process if the reason there is no if it has reason to believe the operative is not engaged in the good faith discussion otherwise conclude that the further consolation would not produce the public interest. Hearing an operator receiving the notice of the proposed safety order made with the content of the notice of any portion of thereof the following writing of the request of the hearing within 30 days following the receipt of the notice or within 10 days of the following conclusion of the informal consolation that did not result in the consent agreement that as applicable the after timely request for the hearing and associated administrator issue the safety order in form of the proposed ordinance within paragraph C through G of this section, conducting the hearing and returning with the office of the chief of the council with the serve of the presiding official and hearing under the section of the hearing will conduct informally without the strictly hearing of the formal rules, evidence in accordance with 192.11 of the respondent may submit the relevant information for the materials calling witness the president arguments with the issue with whether safety order should be issued with the draft the alleged presence of the condition posed with the pipeline integrity risk of the public safety property of the environment. Post-hearing action. Following the hearing with the section of the presiding official with the submit of the recommendation of the associated administrator concerning the issue of the final safety order upon receipt of the recommendation of associated administrator to proceed with the paragraph C through G of the section. If the associated administrator found the facilities that have the condition possess the pipeline integrity risk of the public safety property environment as associated administrator will issue the safety order of the section. Associated administrator does not find the facility such with the condition included with the safety order otherwise not warranted. Associated administrator will withdraw the notice for the properly notified the operator with the written by server the prescribed in statute 195. Nothing of the subsection precludes the HMSA for the operator ends during the consent of the agreement at any time before the safety order is issued. Termination of the safety order. One for any of the remedial actions set forth in the safety order associated with work plans are complete with the determinant of the HMSA. Associated administrator will notify the operator safety order has been lifted. The associated administrator will suspend the termination of the safety order whenever the associated administrator determines that the pipeline facility no longer has the condition of the or condition that pose the pipeline integrity risk of the public safety property of the environment. How is the determination made with the pipeline facility that have the condition posed the integrity risk? The associated administrator behind the pipeline facility have the condition of the pipeline integrity of the public safety, property, environment under the paragraph A of the section. If under the facts of the circumstance of the associated administrator determine the particular facilities and such conditions of the pipeline facility, the component thereof have been constructed and operated within by with any of the equipment, material, technique, for the history of the being subsequent to the failure to use the pipeline services unless the operator involved with demonstrated the such equipment, material, technique of its susceptible failure given the name that is being used in the particular facility. D. What factor of the PHMSA consider the make of a determination with the risk of the condition of the present of the make of a determination on the paragraph C of the section associated administrator shall consider relevant if the character of the pipe or the other environmental pipeline facility, including the age of the manufacturer physical properties, including the resistance to corrosion, deterioration, method of the manufacturer, construction, some of the nature of the transportation for such facility, including their corrosive deteriorative, the quality, the sequence of the which of the material, the transport, pressure for the required with such character of the the geographical location of the pipeline located with particular climatic, geological conditions, including soil characteristics associated in such area that the hazards like wood pipeline proximity, pipeline unusually sensitive to the population density of the growth patterns or air in the area where the pipeline located. An irrelevant recommendation, National Transportation Safety Board issued the connection with any of the investigation conducted by the board. Likelihood of the condition will impair with the serviceability of the pipeline. Likelihood of the condition will worsen over time. Likelihood of the condition presently could develop other than air of the pipeline. What information is included with the safety order? Safety order contained with the following: finding the pipeline facility, finding the pipeline facility with the purpose of the pipeline integrity with the risk of the purpose of public safety, property of the environment, the relevant fact, the form, the basis of the finding, legal basis of the order, and the nature of the description of the in particular corrective action is to be required for the operative dates, which require for the corrective action must be taken to believe whether the appropriate of the deterioration of the order that can PHMSA take an enforcement of the action or effective the facility nothing within section PHMSA issuing the notice of probable violation. Under 192.07, taking the other enforcement action not complying with identified with the facility and or subject with the safety order proceeding. May I petition for reconsideration of safety order? Yes, a petition for reconsideration may be submitted in accordance with 192.43. All right, 241, finality. Except for the otherwise provided in 192.43 and under the directing amendment issued in 192.06 with the final order issued in 190.13, the corrective action order issued in 192 under 192.33 or safety order issued in 192.39 is their final administration action for the enforcement proceeding. 192.43 petition of the reconsideration respond with the main petition associated with the reconsideration order directing amendment of the plan with the procedure under 192.06 with the final order 192.13 and or safety order issued in 192.39. The written petition must be received no later than 20 days after the received order. Respond with a copy of the petition must provide with the chief of the council. Pipeline Safety Hazard Material Safety Administration, East Building, 2nd floor, Mail Stop, East, 26105 1200 New Jersey Avenue, Southeast Washington, D.C. 20590, by email PHMSA Chief Counsel at .gov. The petition received at the time will not be considered. The petition must contain brief statement of the complaint with an explanation as to when that should be reconsidered. The respondent requests the consideration additional fact of the arguments for the respondent must be submitted the reason of the no present with the prior to issuing of the final order following the petition of the section state of the payment of any of the civil penalty assessed. However, unless the associated administrator otherwise protects and provides order included the required corrective action is not stated. Or the associate administrator may grant or deny the whole in part with any of the petition reconsideration without further proceeding. The associate administrator reconsider any of the under the second and final decision. Reconsideration may be issued without further proceeding. The alternative addition of information, data, comment may request that the associate administrator is deemed appropriate. If the policy associated administrator expects additionally issued with the note that taken of the action petition to break reconsideration, the case with the substantial delay of the expected notice of the fact of the date of which expected the action will be taken with the provided with the respondent upon the request whenever practicable. If the associated administrator reconsiders any order of the section of the decision reconsideration final administrative action with the enforcement proceeding and application of the judicial review must be filed with no later than 89 days after the issuance of the decision in accordance with Title 49 U.S. Code 60119A. Judicial Review Agency action in Title 49 U.S. Standard Code 60119A will apply with the standard review established in Title 5 U.S. Standard Code 706. Subpart C, Criminal Enforcement.